All right, the second piece of extrinsic material that we talked about was the general history surrounding a statute, and this is reflected in the Leo Sheep case. And I find the Leo Sheep case really lots of fun. I think the period in history that it's talking about is really fascinating. The statutory background is really interesting, and that makes it, I think, kind of a fun case to talk about. So, what's happening in this case is that the petitioner in the case is the successor in fee. In other words, has a succeeding real estate interest in land that was originally granted under what's called the checkerboard land grant scheme in the Union Pacific Railway Act of 1862. So as the opinion describes it, and as you think about this period of history, this is this period of westward expansion, the period of the wagon trains and so on, and there's an effort to create a transcontinental railway linking the western parts of the country with the eastern parts of the country. And there's a number of ways in which private industry is incentivized to develop this infrastructure. So it's infrastructure that has public incentives, but it's infrastructure that's developed by private entities. Obviously, a rail line is a classic piece of infrastructure. It's kind of expensive to build out, it certainly was back then, and somewhat difficult to build out back then. It requires some land rights that might pass over public land, and it creates sort of a basis that many different other entities can use, like a rail line. Right? You want to use a rail car, you have to have a rail line to start with, and that's a piece of infrastructure. And so these pictures illustrate the way this kind of scheme worked. Here's a picture actually of the original statute signed by Abraham Lincoln, one of my sort of heroes of American history and heroes of American legal history. So you see kind of the era of the statute. And the idea for the scheme is that you've got all this land kind of sitting there, and it's presumptively, public land. And what are we going to do with this land? How are we going to develop it? Now, as we look back on this, of course, we're going to raise today all sorts of questions about, how the U.S. government, federal government, laid claim to these lands, which originally were inhabited by various native peoples, and that raises some really difficult, historical and ethical and moral questions. Those aren't really at issue in the case. The case is just sort of presuming the kind of background. So just for our purpose of discussing the case, we can kind of set those aside. So when we look at the case, right, the U.S. federal government claims that it has the possession and interest in these territories. Now, you are then deciding how are we going to use this land, and you're kind of justifying, as the federal government, we've got to build this rail infrastructure, it's got to go physically on the land. Are we just going to give this land away to the private rail companies and get nothing in return? And so the idea was, well, as we give parcels of land away for the rail lines to be built, we'll reserve alternating parcels, which then can be auctioned off or sold or otherwise used as public land. And during this period of time, really the idea is these are going to be auctioned off to private interests. By auctioning off those alternating parcels, the government raises revenue. And the argument was that the government's going to raise just as much revenue as it would have by selling larger blocks to the rail companies, but it will give those blocks to the rail companies so that they now have an incentive to spend the money to invest in the rail lines. And then as the rail line is built out, as the infrastructure is built out, the overall kind of economic conditions will grow, and it'll be sort of a benefit for everybody. That's the idea of the scheme. Now you can see in this picture an original map from the time that shows in the area of Lake Tahoe, which is not exactly the area in this case, but it's just a good example of this kind of map of what these checkerboards look like. And in this picture, here's a little bit more of a close-up detail where you can see kind of the rail line running through its area of the lands that were granted to the rail company, and and the lands that were reserved. The issue arises in this case because, again, this is much later than the original grant. This land has passed down, and so you have this private property, and then you have an area that has been reserved for public land that's used for recreational uses like hunting and fishing. I'm going to show you this little graph that kind of illustrates a little bit what we're talking about, because the people who wanted to access the public land for the purposes for which it's used, hunting and fishing and other outdoor recreational use, effectively to do it had to pass over one of the parcels of private land. Now as you look at the way I've set this up, this obviously is just sort of a rough heuristic representation. You might think, well, why not kind of go around the public lands and just stay off the private land? And one of the problems with that was just the way this particular land was. There were mountains and other things, and it was just too difficult really to effectively get to the set-aside recreational property without passing through a parcel that was now privately owned. So the claim is that the statute, the original checkerboard statute, Union Pacific Act statute, ought to be interpreted to entail rights of way, to entail easements across the privately granted property to the extent it's necessary to use the other property. And Justice Rehnquist writes for a unanimous court and says, no, we're not going to read the statute that way. And he says, we're going to read the statute looking against the background of the whole history of what was happening when the statute was passed in 1862. And he says, the background of that history is really about finding a way to get this infrastructure built out in a way that gives an incentive to the railroads to build it, and in a way that still gives some revenue back to the government in auctioning off these other parcels. There isn't really a thought at this time about, Rehnquist says, about whether there would be rights of access between the parcels given to the railroad and between these other parcels. They're sort of thought of as different uses, and it's really not in anyone's mind that there'll be some recreational uses and you'd have to cross some of this other land. He says, if Congress even thought about it, what Congress probably thought about was, well, maybe we'll leave this to negotiations. So if there are rights of access of a holder of a private parcel and a parcel that's auctioned off, or of a piece that's reserved by the government and the rail line, you would have some negotiation for what the rights would be. Or if the government wants to create easements in some of the land that has been granted, then the government can do that through using the power of eminent domain. Now, what is the power of eminent domain, right? Constitutionally, the government cannot take property without proper compensation. So the government can take private property if there are adequate reasons to do so. And if they meet those adequate reasons and take the property, then they have to pay the compensation. So, the government's position in this case really is all about, do we have to use the power of eminent domain and therefore have to pay for this out of the public coffers? Or can we declare it as a historic easement based on something implied in the statute, and therefore there's no additional compensation owing to the landholder? Now, it might seem like in this case it's not that big of a deal. There's not that much money at stake. It's just kind of a dirt road running through this property, and that's probably true. But since this kind of scheme was so extensive throughout the developing West, there are many kind of residual grants that remain, and there are many issues that arise over these kind of conflicting rights between historic checkerboard grant properties. What actually ends up developing later as well is, and not too long after these checkerboard schemes begin, because politically there was a lot of pushback even at the time against these schemes as sort of too much a giveaway to the railroads. But not too long after that, there begins to be an interest in actually conserving some of the land for public use. And it's not too long after that they kind of have the beginnings of the national parks movements and other things like that. So these issues about access later on arise even more. You also have subsequent developments in mineral rights. So in a lot of these areas, after the gold rush, you also have questions about coal and oil and other natural resources, gas and other natural resources. So there's many disputes that this kind of question about whether there's an easement that could apply to. All right, so Rehnquist says, look, the Act has specific reservations in it. None of them include easements for recreational purposes, and really the appropriate thing to do, he says, is for the government to use eminent domain. Now, really interesting historical case. There's some good material in the notes that you should take a little bit of a look at after the case. I mean, one question is, well, you know, is Rehnquist really getting his imaginative reconstruction right? And remember, this idea of imaginative historical reconstruction is really a legal process kind of idea. You know, what is the practical kind of problem that the legislature was facing at the time? Does he really get that right, or is he sort of just compressing the history and kind of playing amateur historian? Those kinds of issues are always going to rise in a case like this. Is it more likely, actually, if you think about the historical reconstruction, that if Congress had thought about it, given the debates that were going on, that Congress would, in fact, have wanted to retain some kind of right or easement against the plot? Or does it indeed make sense to think about, well, really the best result is that the parties ought to bargain and come up with some kind of market-based way of supplying these rights? And to what extent do we really think that the subsequent policy of land conservation, which factors into a case like this in the ways that I mentioned before, really comes into play in the way you're thinking about reconstructing this history? So Leo Sheep is a great example, kind of a paradigmatic example of how surrounding history might affect the way you try to interpret a statute. Again, when we meet together in class, we'll run through some other examples and see some other possibilities of ways we might do this with some statutes that are at issue in the courts and otherwise kind of in the public mind today. As another good example of these kind of concerns, we can look at the Sinclair case in our book, which is a Seventh Circuit case. And notice that this is an opinion authored by Judge Easterbrook. Judge Easterbrook is another kind of key architect of the kind of textualism that Justice Scalia also espouses. So what's happening in this context is you have the bankruptcy code, and as you might know, Chapter 7 of the bankruptcy code is liquidation, the business is done, the assets are being sold off. Chapter 11 is reorganization. So the business is going to remain an ongoing concern. Some assets may be sold off, but some of the kind of debt obligations might be canceled by the court. Some of them are going to be renegotiated. It's all going to depend on, you know, kind of the security interests and so on of the different creditors and what kind of debt it is. Well, there's a farm that goes into Chapter 11 bankruptcy, and subsequently Congress passes Chapter 12 of the bankruptcy code, which is a reorganization provision for farms that has some specific advantages for the farm. You know, and the policy behind it obviously is to, you know, kind of promote farms and allow them to recover from financial crises and so on. And the question is, if the case has been filed as a Chapter 11 and now we have Chapter 12, can the case be converted into a Chapter 12 case? Because it otherwise would have been proper as a Chapter 12 case. So here the statute says the amendments, the Chapter 12 amendments, shall not apply with respect to cases commenced under Title 11 before the effective date of this act. So the statute, by its own language, seems to preclude converting it into a Chapter 12 case. So you wonder, well, how can the petitioner even get into court on this without it being a Rule 11 sanction, because the statute says you can't do it? Well, there is a conference committee report, and the report says it's not intended that there be routine conversion of Chapter 11 and 13 cases pending at the time of enactment of Chapter 12, but that courts will exercise their sound discretion in each case, only allowing conversions only where it's equitable to do so. So the question in the case, Judge Easterbrook says, is, well, there seems to be a conflict between the language of the statute and the legislative history reflected in the committee report. So given that there's this conflict, you know, which prevails? And Easterbrook takes the classic textualist line here and says, you know, I'm not going to look at this as maybe some kind of scrivener's error or some kind of more, you know, some kind of legislative mistake or a clarification of some kind of ambiguity. What I'm going to say is, look, the report is just the explanation of the staff of that particular committee. The entity that actually votes on the bill is Congress, the House and the Senate. And then it gets presented and the President signs that text, the bill. The President doesn't sign the committee report. Easterbrook says a committee report could help a court understand the law, but if the report contradicts the text, the statute has to prevail. But he says, you know, that seems to make sense, yet it seems like the Supreme Court sometimes does something else, and sometimes the Supreme Court allows legislative history to prevail over what seems to be contradictory statutory language. And Easterbrook says, what do I do with that? I mean, the Supreme Court seems to be telling me that at least in some cases I can use legislative history even if it looks like the legislative history is contradicting the language of the statute. What's a court to do? Easterbrook says. Well, Easterbrook tries to make a bunch of different moves about how and when we might use legislative history. And he says, well, you know, I can't necessarily just use the plain meaning of the statute. Even as a textualist, statutes come in specific historical contexts, and the words always have a certain meaning. And it could be that a statute helps clarify the original meaning of the words. And in that kind of circumstance, yes, I might find it helpful. It might just clarify what the words of the statute is. But in textualist fashion, Easterbrook says statutes are the law, not just evidence of the law. This is one of those really interesting kind of debates about what is a statute as law. Are the words law, or are the words evidence of the purpose of the Congress, which is really what lies behind the force of law? Easterbrook obviously falls strongly on the side of the former, and he says, a revisionist history, might help me understand something in a historical context, but revisionist judging is not what judges are here to do. Even polling Congress for the opinion of different Congress members about what their opinions might be on a particular piece of legislation is not the law. If I go to each individual member of Congress, I'm likely to get, hundreds of different opinions about what the law ought to be and what it ought to mean. But what ultimately happens is that Congress enacts a text, and it's the text that is the law. And when the text is clear, then we're not going to look at whether there's any other reason to look at legislative history. The text itself is the law. And Easterbrook says, when I look at the text in this case, the text is clear. The text of the statute, notwithstanding the committee report, clearly disallows the conversion in this case. So some interesting notes after this case, which ask, actually, did Judge Easterbrook get it wrong? Here's what we might bring into play. Well, how does the particular text of a statute relate to the whole act? Remember that discussion of the whole act rule. Were there other portions of this statute that actually might have cut the other way, and where that might have raised ambiguities even for someone like Judge Easterbrook, in which case maybe that legislative history is helpful? And you can see that in note 1 in the text. Maybe or maybe not. Another kind of question that this raises is, well, if Scalia and Easterbrook and the textualists are right that it's easy to game a committee report, it's easy to put in language in the committee report through a lobbyist or something else that you might want to later influence a court, does that also happen with the language, the text of the statute itself? Does the language of the statute itself get gamed by lobbyists in order to influence how a court is going to then interpret a statute? I think in general, we'd all probably say, well, sure. I mean, to some extent, to the extent there's lobbying and interest groups behind statutes, which there always are, then the specific language is going to be at issue too. The question would be, though, at what level does that really matter? And in fact, if an interest group is able to get words enacted into law, well, fine, you've prevailed. But do you change that with interpretation through things, words or case citations or other things you get inserted into a report? Interesting kind of discussion, and you can see it talked about in those notes. All right, the last case in our reading for today is actually an English case, which is Pepper v. Hart. And we're giving you this case not because I'm expecting you to know English law, but because it's a good illustration of a jurisdiction that previously had a hard rule that said you don't use legislative history. And where that rule changed in this Pepper v. Hart case, and the debate among the judges in that case about whether it should change or not, or why or when. And it just highlights a little further about how or when or why we might use legislative history and what some of the issues might be about that. So I think it's a little bit hard to follow factually exactly what the dispute is in Pepper v. Hart. So the idea is that the government is providing tuition dollars to schools that are providing public education to people's children. So you have some degree of ability to select a school that your child goes to, and it will be the cost of it will be defrayed by the government. Those benefits that are provided by the government under English law are counted as income, and therefore they are taxable as income. And the statute says the cost of the benefit provided is going to be what's taxed as income. And then there's a definition in the statute that says this is defined to mean the expense incurred in or in connection with the provision of that education. And the issue that arises is that there are some schools that have extra seats. They have capacity, given the facilities and the teachers and all the other resources that they have, to add additional students. They can add new students without building a new building. without buying new desks, without hiring new teachers. So the marginal cost to the school is small, close to zero. So if you calculated this expense incurred in or in connection with the provision of the education, then the value of the benefit provided to the parent in terms of this dollar value would basically be zero. They wouldn't have to pay any taxes. But if you looked at the actual tuition dollars per student, then the benefit would be much higher, and there would be more significant amount of tax that would have to be paid. That's the issue going on in the case. So there is legislative history in the debates in Parliament that suggests pretty strongly that the expense incurred was actually meant to be the marginal cost, not the cost of tuition, but the marginal cost, so that in cases like this one, where the marginal cost was close to zero, there's really not going to be much tax. But the previous English rule had been that legislative history is inadmissible, and this is a rule with a long and deep tradition, a lot of which has to do with the fact that Parliament's an older institution even than Congress for sure, and that debates happen, and that there's a reporter. When there's agreement on what the actual legislation is, there's a reporter kind of writing it down, and then enrolling it, literally rolling it, and putting it, in storage, and that's kind of the law. So it has kind of deeper historical reasons. So of the judges deciding the case, there's agreement that the benefit should only apply to the marginal cost, but there's differences about whether legislative history is necessary or appropriate to reach that result. And Lord Mackay writes that, I think I can simply read the statute on its face without legislative history to get to this result. And I don't like the idea of using legislative history. This is contrary to our rule. And he says, the appellant argues that, well, we can be selective about this. We can use it only when we are confirming the meaning of the text as it is, only, or if the meaning of the text is ambiguous, or if the ordinary meaning seems absurd or reasonable. And so it's only limited circumstances under which we'd use it. But Lord Mackay says, yeah, but you know what? In any contested case involving a piece of legislation, it's likely that one or more of these conditions is going to apply. So I just think it's going to apply all the time. I think it's going to be too expensive. It's going to make lawyers do a lot more research than they otherwise would have to do. That'll increase the cost of litigants. The old rule should still apply. Lord Brown Wilkinson writes what becomes the new rule and says, well, no, actually we should modify the rule to the extent that we're using legislative history as an aid to construction of legislation which is ambiguous or which would lead to an absurdity. He says that we should only allow it, though, not routinely, but only where the material clearly discloses the mischief aimed at, right? What the problem is that the legislation is trying to solve, or what the intent is in the legislation. And he further says we're going to limit it, we should limit it to statements of the minister or other promoter of the bill. So it's the legislative history only of the person or persons who is or who are really the prime sponsors of the bill. An effort here to perhaps try and limit some of the possible gaming. Lord Brown Wilkinson further says, yes, I agree that the statute is the actual words that Parliament has enacted, the law is the actual words of the statute, but Parliament never intends an ambiguity, right? We've seen this before in some of our discussion of legislative history in the American context, the idea that courts very often, even though we know when the sausage gets made it's really messy, courts are going to sort of as a principle of law say, well, we have to sort of assume that Parliament, Congress, whatever, doesn't intend ambiguity. And he further says, well, courts do this anyway. Courts often use legislative history or refer to it, maybe even without putting on the record that this is what they're doing. But if they're doing it anyway, let's kind of bring this out into the light and let the true intention of Parliament be known. And so he announces the test that if the legislation is ambiguous or obscure or leads to an absurdity, then we can rely on a limited set of material if those statements are clear. So this chart actually just kind of contrasts the different approaches in this case that Lord Mackay would have taken and the approach that eventually becomes the rule that Lord Brown Wilkinson takes. Now, when we get together in class, again, we'll look at some examples, and we can also talk a little bit about, well, is the Old English rule really the better rule? Is this current English rule announced in Pepper v. Hart a good rule, and do its limitations work? Or is the kind of mainstream American approach, which is really kind of ad hoc and depends on the judge and depends on what the source of legislative history is that the better approach? And we can talk about some of those distinctions, and we'll work through some examples when we meet together in class.